All right, hello everyone, and welcome to another edition of Employment Law Q&A. My name is Alex Lucifero. I'm an employment lawyer and partner with Samfiru Tumarkin LLP. We are the employment lawyers in Canada across a number of provinces: Ontario, British Columbia, Alberta. If you are tuning in and viewing us from those provinces right now, this is your chance. This is your chance to ask a question about your workplace, to ask a question about your employment rights, or even perhaps your employment obligations as an employee or an employer for that matter. Whether you're an employee or an employer, if you're dealing with a situation at work, if you are struggling with perhaps the way your manager or your boss is treating you, or if you have a disgruntled employee perhaps, and you're wanting to know what your options are as a manager or as an employer, go ahead and ask your questions right now online. This is your chance. This is your chance to speak with an employment lawyer live on the air. Go ahead and post your question. Again, this is a live Q&A. That's what we're here to do. We're here to take your questions, answer those questions, and get you pointed in the right direction when it comes to your employment rights. As an employment lawyer, this is the bread and butter of my work. I speak to people every single day, speak to dozens of people every single day, and help resolve their workplace problems. Problems arise all the time in the workplace. It's not uncommon at all that employers and employees will have disputes. The disputes can be far ranging. Again, if your boss is mistreating you in some way, maybe you're dealing with someone who's very difficult, you feel like you're being bullied or even harassed in the workplace. Again, that could be your boss. It can also be a coworker. You as an employee should know you have the right to a safe and healthy work environment. And so if you're struggling with that bullying in the workplace, you have recourse as an employee. As another example that we see very often, if your employer is changing the terms of your employment in a significant way, maybe they're asking you to accept a different position within the company. Maybe they're asking you to take a pay cut or to change your compensation structure. Or alternatively, maybe you've been temporarily laid off. Maybe your employer is struggling financially and you've been asked to go home for a little bit, sit on the bench, so to speak, and they'll recall you back to work when they need you. All of these things trigger protections on the part of employees. As an employee, you have recourse, you have choices in situations where your employment terms are changing. You actually have the right to say, no, I don't want them to change, and either force the employer to comply or perhaps leave your employer with a severance package. It's what we call a constructive dismissal. I'll get to that in a sec. Of course, if you've been let go from your employment and you're faced with a termination letter and you've been made an offer of severance, or perhaps you haven't been made any kind of severance offer. Maybe your employer is alleging that you did something terribly wrong in your employment, either misconduct or poor performance, and you haven't been offered severance at all. Again, all of these things, any significant changes to the terms of your employment, and certainly a termination, warrant a discussion with an employment lawyer. Warrant you right now asking a question of us. Put your situation to us. We don't need to know your exact employer's name. We don't need to know, every single detail of your employment. Send this in a quick question, right? Even if it's a severance question, tell us how long you've been with the company, your position there, your age. I'm more than happy to get to that question right now. Again, guys, this is your one and only chance really to speak with an employment lawyer today live on the air and get your question answered. I see a couple of questions coming through already, which is great. Thank you guys so much for posting those questions already. Big Al and Valerie on Facebook, I believe. I will get to those in a sec. I first, and as usual, want to do two things. Number one, I want to give you our contact information so that if you maybe you're a little too shy to ask your question online, go ahead and contact us at the office. First place to start, our website, employmentlawyer.ca. You see it on the screen right now. That's employmentlawyer.ca. Not only do we have a ton of resources and articles and information on the website, you can actually do some research yourself and look up whatever specific topic you're dealing with. We also, of course, all of our actual contact information there. So, of course, you can call us at the office. Our phone number is there. You can reach individual lawyers and their email addresses if you need to. Otherwise, you can email us directly at help@employmentlawyer.ca. You just saw it on your screen right there. That's help@employmentlawyer.ca, help@employmentlawyer.ca. go ahead and send us an email. It doesn't take much. It's obviously free. Go ahead and give us a brief description about the situation that you're dealing with. It's strictly confidential. We are not allowed to share that information with anyone else. Email us there. Give us the situation that you're dealing with, and I promise someone will reach out to you and get back to you with your situation. Oftentimes, you can be put in touch with a lawyer very easily and very quickly. All right, that's number one, our contact information. Number two, I wanted to talk about a matter that's come across my desk recently, and it is a question that came up again, and that we're starting to get questions about again from various employees across various industries. But it had to do with a headline that was making the news earlier this week, and it's to do with Twitter and just the tech industry in general. There's been lots of news about Twitter specifically, but also lots of employers calling employees back to the office, calling employees back to the physical work location, and not allowing employees to work from home anymore. And that's triggered a ton of calls. And we thank you for those, by the way. We welcome employees reaching out to us and asking these kinds of questions. But lots of people, I mean, a good number of people have reached out to us and said, hey, my employer is doing this. My employer, I've been working from home for almost 3 years now. My employer is asking me now to return back to the office, some effective immediately, others effective a couple of months from now. And so in some cases, we've seen, starting January 1st, we'll require employees back in the actual physical office space on a full-time basis, Monday to Friday, 9 to 5 in most cases. And people want to know, is my employer allowed to do this? Can they force me back to work? Lots of people have been working from home successfully, without a hitch. And they actually, of course, enjoy working from home. You save the commute time. You save the expenses of having to drive into work every single day, or paying for public transportation every single day. And so people want to know, can my employer force me back to work? And the general answer is this. So if your employer implemented a work from home arrangement on a temporary basis, strictly because of COVID, and it was always understood within your employment that this work from home scenario was a temporary solution in response to COVID-19 and the shutdowns and the requests by the government to limit interaction with others, etc. If it was always clear that this was a temporary measure, guess what? Your employer is allowed to call you back to the office. They're allowed to default back to kind of the status quo, which if your status quo was Monday to Friday in the office full time, well, then that was effectively an implied term of your employment. And this period of time, again, if it was considered temporary and understood to be temporary by all parties, they are allowed to move away from that temporary position. And some people are in that situation where their employers made it crystal clear that work from home was temporary and that they'd eventually be going back to in-office work. And again, if that's happening now, so be it. Your employer is allowed to dictate that to a certain extent. And again, to revert back to the implied terms of employment that existed pre-COVID. Now, some people are not in that situation. Some people are in the situation where, whether it's prior to COVID or even at some point during COVID, they were assured by their employer that effectively this work from home situation had become effectively a permanent term of their employment. So they implemented something like a work from home arrangement, whether that's full-time, right, working entirely from home, or even part-time, where maybe you're working from home 3 days a week, maybe going into the office twice a week. For lots of employees, that effectively has become a permanent, established term of employment. Again, whether that was prior to COVID or even during COVID. And if that's a current term of your employment, and it was not a temporary measure, but a permanent measure, well, then you're actually allowed as an employee to say no to returning back to the office full time. This has become an established term of your employment. Your employer cannot make a significant change like that. At least they can't do it without reasonable notice of the change. So the answer to the question of, can your employer force you back to the actual office or force you back to work where you are working from home because of COVID, really depends on whether that work from home arrangement was very clearly temporary or not. If it wasn't temporary, if it was an established, effectively permanent term of your employment, you are allowed to double down on that position and say, no, I'm not going to change that term of my employment. If, on the other hand, it was always understood to be temporary, well, then you have to play ball with your employer, and you have to effectively concede that they're allowed to bring you back to work. As a last point, guys, what I would suggest is every single case here is very context specific and very fact dependent. There may be other reasons why you need to work from home. They could be medical reasons. They could be childcare reasons. These factors will ultimately change the analysis, most likely in the employee's favor. And so if you're struggling with this issue, if you're not sure about whether your employer can force you back to work or not, and I force you back to work, I mean into the actual physical office, don't just guess. Don't just take your employer's word for it. You need to speak with a professional. You need to speak with an expert. Give us a call. Send us an email at help@employmentlawyer.ca. Let's have a chat. It doesn't take much. Let's have a chat about it. Let's brainstorm. Let's figure out, number one, the way the law works in your particular scenario, right? And then figure out what your options are and ultimately what your best option is and what you should be doing. Again, we as employment lawyers at the firm do this every single day with employees. And so again, don't be shy to reach out to us. It is worth having that conversation. All right, guys, I will leave it at that because I see a couple of more questions here, and let's get to it because, well, the questions are more interesting than just me rambling on about various employment law topics. So let's get to it. Just to recap, again, my name is Alex Lucifero. I am an employment lawyer and partner with Samfiru Tumarkin, LLP. This is a live employment law Q&A. Go ahead and ask your questions about any issues you're dealing with at work. If you're struggling with any kind of workplace issue and you disagree about what your employer is doing, chances are there is an employment law that addresses that issue. And so again, don't be shy. Go ahead and ask that question. You can keep it general. You don't have to go into any particular or confidential detail. And I promise I will get to your question. We've got about 27 minutes left on the call, so or on the live stream. So let's get to it. First in line today was Big Al. Big Al, thanks very much for your question. Big Al asks, laid off after 6 months with 1 week pay per law in lieu of notice, and an additional week if signed the release. Your calculator shows I'm entitled to 3 or 4 months severance. How? Big Al follows up. How involving a lawyer would affect my prospects of getting a new job in terms of good reference from my previous manager? What fees do you charge? How? What guarantees do you give? By laid off, I mean terminated without call. Al, great question. It's a question we get very, very often. And here's how it works. By default, the default setting here is that an employee's severance entitlements have to be determined in accordance with their age, position, and years of service. The older you are, the longer you've been with the same company, the more senior your position or the more specialized your position, the more severance you're going to get. Very interestingly, short-term employees such as yourself are actually entitled to proportionately greater periods of severance as compared to even longer-term employees. For example, what I mean by that is, as a 6-month employee, and listen, depending on your age and your position, Al, and feel free to throw that information into the chat, and I'll give you an even more specific answer. But even as a 6-month employee, your severance entitlements could very well be 3 or 4 months. That's not uncommon at all. It's actually a pretty standard number. If you're, in your, let's say, late 50s or 60s, and if you were in a manager or senior management level position, that number might even be greater than 3 or 4 months pay. So again, 3 or 4 months pay for just the 6-month employee is significant, but that is indeed the way the law works. Now, in your situation, Al, I would want to also have a look at any employment contract you might have signed with the company. It is possible, and we need to figure out whether there is anything contractually by way of a signed employment agreement or an offer letter or an employment contract that limits your severance entitlements in some way. That is a possibility. So I'd want to have a look at your employment contract as well. I can also tell you this, and you mentioned, how do I get a good reference from my manager if I'm going to try and negotiate severance? I could tell you this as a fact, and I have handled thousands, literally thousands of negotiations when it comes to severance over the course of my career. Negotiating a severance package does not burn bridges. It does not destroy your odds of getting a reference letter. If you approach this in the right way, and that is professional, respectful, even by way of legal counsel, as long as you don't go at an employer making wild allegations and wild threats that are completely unfounded, you will not burn any bridges. In fact, as part of our severance negotiations, we are actually able to almost always, I would say, negotiate a letter of reference within a settlement term. So don't worry about ruining the relationship or not getting a good reference. Al, that's not a reason to accept a severance package that's far less than what you're actually owed. At the end of the day, this is a transaction, right? Your employer is looking to pay you as little as possible, and you need to secure your short-term financial future as well as possible to hold you over until you can find that next job. Let me address your other questions. Your last question was, what guarantees do you give? At this point out, I can't give you any guarantees. I haven't seen the documents. I haven't spoken to you. There are no guarantees in life, and there's certainly no guarantees here either. What I can guarantee you, however, is that you absolutely should be speaking with an employment lawyer about your situation and before you sign off on their 2-week severance offer, because there is quite a good chance that 2 week severance is far too little for a 6-month employee. And that might be shocking to hear. It might be shocking for a lot of people to hear. I'm not making this up. This is the way the law works. Last question with respect to fees. Al, you asked, what fees do you charge and how? In a lot of these cases, when it comes to severance negotiations, we can operate on the basis that we won't charge you unless we actually get something better for you. And so it's what we call a contingency fee. We can also operate on an hourly rate basis, which is the kind of traditionally the way lawyers charge fees. We charge for our time. What fee structure is correct for you depends on the particulars of the situation. Depends on how much you might be owed, how much you were earning, what the risks involved are. Oftentimes you have the option of deciding whether you want to work on a contingency fee basis or an hourly rate basis. And again, there are both pros and cons to both approaches. Big Al, I think the takeaway here, at the very, very least, I have to say, in case it's not obvious, is that before you sign off, you need to have a conversation. Send us an email, give us a call. Our contact information is easily findable. We've already handed it out a bunch of times over the course of this segment. Have a chat with an employment lawyer. Let's figure out what's what in your situation. Let's have a look at your contract. Let's have a chat about what your actual entitlements are. Let's have a chat about what your prospects for employment might be. Let's figure out whether their severance offer is reasonable or not. There's a decent chance it's not enough, that you're owed more. But again, it's just worth having that conversation before you make a final decision. Reach out to us, Al. More than happy to have a chat. And hopefully that answers your questions. All right, next up in line, and thank you for the question, Al. Valerie, thank you as well for your question on Facebook. Valerie asks, I've always performed really well at hitting sales goals. Despite this, proposals on cutting commissions have arisen lately. I still get paid salary, but I'm wondering if this can be allowed. Excellent, excellent question, Valerie. And I have to say, I see this all the time, particularly with salespeople. Salespeople will hit their numbers out of the park and do exceptionally well. And salespeople can earn a very, very good living on commissions and bonuses, etc. Unfortunately, what I do see, speaking to many salespeople over the course of of the weeks and months and years, whenever a sales group does very, very well, the response is not necessarily to be rewarded by the employer. Oftentimes the response is, hold on, we need to rein in these people's commissions. They can't be earning this much. We need to restructure the compensation package. We need to restructure the commission calculation. And Valerie, I can tell you that if these commission cuts are going to have a significant impact on your compensation, and by significant, I don't even mean that much really. If they're going to reduce your pay by either 10% or thereabouts or more, that is going to be considered what we call a constructive dismissal. It's basically a breach of contract if your employer does that. If that happens, Valerie, and it sounds like it hasn't happened already, it sounds like it may be happening, please do yourself a favor. Do not accept those changes off the bat. We need to have a chat about what those changes actually are, the impact that it will have on your total compensation. If the impact is negligible, well, then maybe there probably isn't much of a reason to contest. If the changes are significant and they're going to negatively affect your salary by a good amount, you need to draw a line in the sand. And the first thing I would recommend you do is that you tell your employer, I don't feel comfortable with these changes. I'd like to stay on the same commission structure and compensation structure that I've been enjoying for the past little while. If your employer rejects that position and says, too bad, we're forcing this on you, well then, Valerie, you'll need to make a decision. Do you want to accept the change and keep moving with your employment? In which case you'll have to accept that commission reduction. Or do you want to treat that as a termination, right? Obtain your severance entitlements, obtain your severance entitlements on your full compensation package, on the unreduced salary and commission amount. By the way, commissions are included in the calculation of severance, and walk away from your employer. Oftentimes, as difficult as that might sound, walking away with severance is the best option, because once you allow your employer to make a change like that, and this is the case with temporary layoffs, it's the case with demotions or changes to your position. Once you allow an employer to do that once, you're then giving them implicitly the green light to do it again and again and again. You've accepted at that point in time that your compensation can be changed moving forward. And so if they change it again the next year and it's another negative change to your commission calculation, you won't have recourse the second time. You have to take a stand the first time a significant change happens, whether that's a reduction in your commissions or a reduction in your base salary or a change in your position or a temporary layoff. Whatever the change might be, you have to draw a line in the sand immediately. Otherwise, you lose the right effectively to complain. It's also the case, Valerie, that you need to act relatively quickly in a situation like this. If you get the commission calculation, don't sit on it for 2, 3, 4, 5, 6 months and then raise an issue. You need to act right away. And again, that's not to say that you should respond to your employer in the moment as soon as you get the document, but you should be reaching out to us right away, having a chat about what your options are and taking it from there. Hopefully, again, that answers your question, Valerie. It's an excellent one, and we see it all the time. We see changes to compensation packages, to commission structure all the time, and a lot of times it very well is a constructive dismissal, and that gives you leverage. That gives you bargaining power in the situation to either force your employer to back down or to get a severance package and get moving on with your career. All right, next question. Philip asks, I have arthritis, but employer says they don't allow LTD, require me to resubmit each year. Is that allowed, i.e. limited modified work duties? Philip goes on to explain, plus my performance reviews do not take into the fact going into other mode too often. I'm not sure what that means, Philip, but I think I get the gist of your question. I don't know what you mean by don't allow LTD, Philip. So it's possible that your employer doesn't have LTD insurance coverage through its group benefits plan. That's certainly possible. Not every employer will have disability benefits coverage through their group insurance. But that doesn't mean that you can't take a medical leave of absence. Those are two separate items. A medical leave of absence, if there is no disability insurance, can be unpaid. Right, so you can receive employment insurance during that period, or sickness benefits as they're called. Your employer doesn't have to pay you for a medical leave of absence, but they do have to allow you to take a medical leave if you're physically unable to work. So your employer can't force you to work if your doctor is saying you can't work. I hope that's clear, and perhaps I'm stating the obvious there. Now, as far as accommodations go, your employer has to accommodate you and your employment. They need to accommodate to the point that's called undue hardship. That is the language that the law uses. What that effectively means is that it's accepted it's going to be difficult to accommodate any physical limitations that you have. Maybe you can't lift certain things. Maybe you need more frequent breaks. Maybe you can't do certain tasks. That's all okay. Your employer cannot punish you for that. And so certainly they cannot take that into consideration in performance reviews, as I think you were alluding to. And they also have to, again, they have to accommodate you in that situation, even if it is difficult, even if it is inconvenient. That's not a good enough excuse. It has to effectively be near impossible to accommodate you for them to be able to say no. So it really depends, Philip, on the kind of job that you're doing, the kind of accommodations that you need. Again, if it's very basic things like, you can't lift over a certain amount of pounds, and you can't do certain items, and you have to take more frequent breaks, or maybe you need a shorter work schedule. Again, your employer has to play ball. I mean, it's really as simple as that. If your employer is giving you a hard time, Philip, again, I have to say, reach out to us, give us a call, send us an email at help@employmentlawyer.ca. Let's have a chat. Oftentimes, we could become involved in a situation like this. I'm actually dealing with this scenario right now where we will send a letter to an employer and we will say, either you need to accommodate this employee or pay him a reasonable severance package, right? Make him a good offer and he can continue on in his career. And a lot of times we're able to resolve these situations in exactly that way. Philip, if you're in Ontario, if you're in Alberta, or if you're in British Columbia, give us a call, send us an email. These are the kinds of situations where you need to have a chat with an employment lawyer. And so good for you for asking the question because it's a legitimate one. And good for you for reaching out to us. All right, guys. Two last questions. One from Colton, and I have about 4 minutes here, so I'll try and get to them as substantively as I can. Colton asks, after repeated failures to pay me on time, my manager is asking I take a pay cut. I'm very tempted to leave as this doesn't seem like it will end in my favor. Is there any way to get what is owed to me? I'm sorry to hear about the situation, Colton. That's tough if your employer isn't paying you on time. It's a delicate one because the reality is that if they aren't paying you on time, and perhaps that's because of their financial circumstances, I do have to say, a worst case scenario for an employee is for an employer to claim bankruptcy. So Colton, if your employer is on the verge of bankruptcy and they owe you wages, that is a huge, huge red flag, because if they do end up claiming bankruptcy, I'm not talking about the company shutting its doors, right? Shutting your doors and ceasing operations is one thing. That's not bankruptcy. Filing for formal bankruptcy, or what's sometimes called receivership, is an entirely different thing. And it's a legal proceeding in its own right. If your employer is filing for bankruptcy, Colton, I hate to say it, but that, you become a creditor like anyone else, and you're probably going to get cents on the dollar from the wages that you're owed. If that's not the case, Colton, if your employer isn't filing for bankruptcy, there's no question you're owed those wages. Even if the company folds, right, and closes its doors, you are still owed those wages, full stop. Your employer not paying you is also what can be considered a breach of contract. Again, it's this concept of constructive dismissal that I've been referencing now a couple of times over the course of the show. Failing to provide an employee with their pay is effectively a breach of contract. So not only would you be owed those wages, Colton, you would also be owed severance. Don't walk away from a scenario like that. You probably want to engage an employment lawyer. Have an employment lawyer send a letter to the company very sternly saying you owe this employee these wages, you owe Colton these wages by X date. We give them a firm deadline, right? Failing which, not only will you owe him those wages, you'll also owe Colton severance based on his age, position, and years of service. And again, as long as your employer isn't claiming bankruptcy, Colton, you are owed that money. And it's not only wages, it could also be severance. Again, another opportunity to reach out to us, give us a call, and let's have a chat about your options. I suspect that's probably the best option for you. Last question here, and frequent viewer, I believe, Helen 2006. Helen, thank you for your question. How much more compensation does human rights award roughly if it substantiates age discrimination? Can human rights deal with retaliation after reporting bullying? Helen, the answer is yes to both questions, or at least yes to the second question. How much could the Human Rights Tribunal in Ontario, now I'm referring to, award for discrimination? The answer is it really depends, Helen, on how egregious the behavior is. I can tell you, at least in Canada, that the awarded for human rights damages aren't what you see in the United States, for example, where you'll receive hundreds and thousands of dollars in awards. Although, if we're talking about very, very egregious stuff, like sexual abuse or discrimination in that respect, you can see awards in the six figures numbers. Most awards for age discrimination, I have to say, Helen, will be in the tens of thousands of dollars range. The interesting thing about a human rights tribunal is you can be awarded past wages or wages lost, which can also be very significant up until the date of the hearing or the trial. But again, the answer is very, very context specific. It could range anywhere. If there are damages awarded, on the low end of the range, it might be something as minimal as $10,000, and again at the higher end of the range, we might be talking about six-figure awards. Hopefully, that at least points you in the right direction. And again, to answer that second question, yes, they can deal with retaliation when it comes to bullying and harassment in the workplace. We will leave it at that, guys, and we are bang on the time here. We're at exactly half an hour. Thank you all so much for tuning in. Thank you, Al and Valerie and Philip and Helen, for asking your questions, and Colton as well. It's been a pleasure helping you all out. Again, if you have any additional questions, don't be shy to reach out. You know where to find us. And we also do these live Q&As very, very often. So if you didn't get a chance to answer your question, or if you're curious, you might want to ask a question on the next one, just look out for that next segment. Until then, have a great afternoon and great rest of the day to everyone. We will see you next time. Take care.